Hello, this is Dave Siegel. Thanks for joining us for another edition of Legal Action. Today we're going to be talking about divorce law, and I have with me once again my co-host Jesse Barrientes. Jesse, welcome.
Thank you very much.
For those of you who don't know, Jesse is a DuPage County attorney who handles a large facet in many areas of the law, and today we're going to be talking about another one of your areas, which is divorce law. Is that correct?
That's absolutely right.
Tell me what's been happening.
Well, I'll tell you, first, divorce is so prolific these days, and that's primarily because the state has really made it easy for someone to secure a divorce. Now, we can talk about costs a little bit later on, but realistically, somebody could go online and get the forms and secure a divorce themselves. But there are some basic kinds of things that I think people need to know about divorce. One of those things is the jurisdictional requirements. You're required to be a resident of the county and state for 90 days preceding filing your divorce, and at the time of what they call the prove-up, which is when the divorce is concluded as well. There are some other, well, let's just talk generally. I mean, Illinois is a no-fault state. That means that you really don't need grounds to prove up a divorce, although there are grounds listed in certain situations. One of those things is irreconcilable differences. Now, you're familiar with that too, because I know you do a divorce as well. So, what?
Right. I basically describe irreconcilable differences as differences that have led to the irretrievable breakdown of the marriage. Attempts to work out those differences have failed, and the parties consider the marriage over. That's my definition of irreconcilable differences. Is that how you see it?
That's how I see it too. And explain a little bit for the folks at home when you do irreconcilable differences. What are the requirements? As I understand it, there's a 2-year period and
Right.
there's a 6-month period.
There is
of
a
waiting?
2-year statutory waiting period for irreconcilable differences unless the parties agree to reduce that 2-year waiting period down to 6 months, and they can do that by written stipulation. So effectively shorten the amount of time that they have to be separated. And that's another key factor. Separated does not mean living separate and apart, 2 separate households. They could be living as roommates within the same household that is still considered separate and apart as long as they're not functioning properly as husband and wife. So you really don't have to be separated at all. You just can't be functioning properly for at least 6 months.
They can still live together, so it doesn't matter just as long as you're not living as husband and wife would.
Sure. And many times they cannot afford to live separately for economic reasons, so they must stay together during the course of their quote-unquote separation period.
Yeah, that's a big consideration as well. There is also physical and mental cruelty. I think pretty much that physical cruelty speaks for itself. And
Right.
I don't know, we may do another segment maybe sometime on orders of protection and those kind of things. That's where criminal law kind of intersects a little bit with divorce law and family law. But you have mental cruelty as well.
Right.
And that would be what? That would be, for example, belittling your spouse, treating them with such disrespect, maybe swearing at them. What else, Dave? Would you?
Any kind of conduct that really makes it unlivable for one party, telling the party that they don't love them or they don't care to be with them, derogatory words, swearing, anything that causes conduct which upsets the other party would be mental cruelty if it continues on an ongoing basis without any cause or provocation on the part of the person.
And that's exactly the key, without any cause or provocation.
Right.
Because we know sometimes we do things and we probably deserve some of the things that we get back for that. But that's the
Right.
key feature of using that particular area,
Right.
ground, physical and mental cruelty. There's also another distinguishable difference. Unlike irreconcilable differences, where there's a 2-year period that can be waived down to 6 months, with physical and mental cruelty, there's no waiting period whatsoever.
That's correct.
Correct?
You can go down to the courthouse the very next day and file a petition for dissolution if your spouse strikes you the night before or engages in mental cruelty over a series of days, I would say, not just one day for that. But certainly physical violence, you can immediately go down and file a petition for dissolution, and you have your grounds right there.
And don't have to wait. And I guess that's the other thing too. Sometimes people may not agree, and they file a divorce together, and somebody maybe doesn't want to waive the 2-year period of separation. So a lot of times, and what we do in a lot of our petitions, and of course it's up to the clients, it goes on a case-by-case basis, we usually allege as well mental cruelty. I mean, dependent upon the case. We always allege something that obviously is accurate because it's a document that you're testifying to as being true and correct. So again, on an individual basis. So a lot of times that's what you see, irreconcilable differences as well as mental cruelty or even physical cruelty. Now, there are a couple more. What happens if you just leave?
Well, I was going to say one less common of the grounds would be desertion. And desertion is where a party has left the whereabouts for more than 1 year without any information as to where they're at, and the person who's filing the divorce did nothing to cause or provoke that person to leave. So you have to wait 1 year for desertion, which is often confused with abandonment, which is used in other jurisdictions and other states, but there's a difference. Desertion is just the party is gone for more than a year without any information as to their whereabouts.
So if I just, the guy or the husband or wife tells the other spouse, hey, listen, I'm going to the corner to get some cigarettes, and then, never comes back, and the other person has no clue, then that's a ground that they can use as well.
That is.
Right? And there's really
it's
one...
also mentally cruel,
mentally
isn't it?
cruel, it sure is. I guess it is. The last one would be adultery, and I think that's pretty straightforward. Dave, how do you see?
Yeah, I know nothing about that.
Okay.
I do a lot of uncontested cases, and people do not like to see that in the documents. Grounds are not a basis for division of property. You can be the worst spouse in the world. You're still entitled to your fair share of the equitable estate. You're still responsible for your share of the debt. So people do not like to see adultery in the documents. It's not necessary anymore. Obviously, that would be an irreconcilable differences, wouldn't it, if your spouse is cheating?
It would, but sometimes, and this is what I found, unfortunately, and I'm sure the folks at home know as well, that people like to strike out at each other and like to hurt each other. And so, and I don't know whether or not they really realize that these are public documents, that people could have access to them, they're public records. Right. And so they want to put that ground in there because they feel that person has committed adultery, and they want to make sure, and they want to feel like they're vindicated, and they want to put that in the documents. And so right. Sometimes...
That's true, but the net effect in terms of division of property is not that important. And let's move on to that, because divorce is all about getting past the grounds, getting into the court, the arena, the ring, whatever you want to call it. And then it's all about who gets what, where, how much, when, how are things divided, correct?
That's right. It's an estate, similar to some of the other shows we talked about in terms of a bankruptcy estate. It's an estate. You have a marital estate. Marital estate, right. You have marital property and non-marital property, and we'll probably get into that maybe in a later show. But what essentially happens is that there are so many factors in terms of those distributions and how those things are split. The debts, for example, are part of the marital estate, so you're going to be responsible for a portion of that debt. I mean, it depends on how long you're married. Let's talk, for example, about maintenance, which is formally called alimony. That's the way they used to call it, which is really spousal support.
Correct.
And there are various forms of maintenance.
Why would someone need maintenance?
Someone would need maintenance because, for example, say they've been married for a long period of time, and that the spouse, and we're just going to say the wife. And it doesn't have to be. It could be. I've seen situations where the roles were reversed, and it's the husband. But for this example, we'll use the wife, and she's the homemaker, and she's raised the kids, and she's taken care of the kids, and now she's spent all of this time, 10, 15. 18 years raising the kids, and she doesn't have any experience or any skills with respect to what the economic market as far as they're concerned. And so what maintenance will do in some cases is to give that individual, that spouse, the ability to get put back, to get some training. They call that rehabilitative maintenance, to get her back in a situation so that she can earn a living and that she'll be able to support herself. Right. But there are various forms of maintenance. There's, for example, temporary maintenance, which is just maintenance for a temporary time, for a specific period of time. There's permanent maintenance, which is maintenance. It sounds a little funny, but I mean there are little caveats that go along with this. That's paid for a prolonged period of time. However, maintenance. And well, let me finish, and then we'll talk about what I just had on my mind there. The last is maintenance in gross, and that means there's a specific amount. Okay, I'm going to pay maintenance in the amount of $100,000, and that's going to be the total amount of maintenance that I'm going to pay. But it's going to be split up into 4 installment payments.
It's non-modifiable, though.
Well, as long as you have that included in, usually, typically people get together and they do a judgment and they have a marriage settlement agreement if they agree on things. And as long as it's included some language in that, in that document that says it's not modifiable, then you're okay. Maintenance can be modifiable. For example, temporary maintenance, which is paid for temporary period of time, often contains a period in which it's reviewable. And what that means is they're going to go back and they're going to look at the situation and see the need to either continue it, to increase it, to decrease it. And in fact, people can go in and seek modification of the maintenance, if that magic language is in there, in order to decrease it. Let's say the maintenance that I'm paying is based upon what I'm earning. And unfortunately, let's say that, hey, I lost my job, or I'm earning half the amount that I was earning before. And so there's been a substantial change in the circumstances, and then they go in and look at that and maybe adjust on that portion. Now let's say I've gotten another job where I'm making twice as much. Okay? And there's a need on the part of my ex-spouse for an increased amount of money. So, and we'll go through the factors in just a little bit. But go ahead.
In general, is it safe to say if it's a short-term marriage and the parties are both making approximately the same amount of money per year, then maintenance would not be an issue?
That is safe to say. If you're just married for, and believe it or not, there's been some marriages. Well, just look at Hollywood, I guess, right?
Right.
Married for a month or 2 months or 3 months. The likelihood that somebody, even if the other person isn't working, the likelihood that that person is going to get maintenance is very slim. I mean, you can't guarantee anything because it depends on some factors, but you never can tell. But what I wanted to say, though, was that maintenance can be terminated.
Sure.
On the triggering of several events. One would be...
What's the most obvious?
Well, I don't know. Most obvious to whom? Right?
Death.
Death, right. Death of either party will terminate maintenance. Another reason why maintenance would be terminated would be if the party who's receiving maintenance was remarried. Now, that's important. Right. It's not the party who's paying maintenance, because then I think that sometimes people might just get married to avoid their maintenance obligation, or sure. Maybe very often that's maybe why they got divorced in the first place, because someone else was in the picture. And so it's the person who is receiving maintenance. If that person gets married, then that'll be terminated. And then finally, if the person who's receiving maintenance cohabits and takes up residence with somebody with a conjugal relationship, then the maintenance will also be terminated. Now, proving that, saying one thing is saying it, but being able to prove it is another matter.
Right. There are plenty of people who lived separate just to continue to receive the maintenance, even though they were in a serious, committed relationship with another party.
That's absolutely correct. And because, when you think about it, depending upon how much that is, that's a continuous amount of income, depending upon what type of maintenance it is. So I guess when we talked a little earlier about saying, permanent maintenance, that's kind of a misnomer, because it depends on the happening of any of those kind of things.
It's all about the money, isn't it? Just
it's about the money. It sure is.
Right. Let's talk about, speaking of money, talk about the tax ramifications of the person who pays the maintenance as opposed to the person who receives the maintenance.
Well, generally, and it's very important that you make sure that you word that in the marriage settlement agreement, the document for tax consequences, that the person who pays it, generally it's deductible for that person, and it's reportable income, and it's going to be taxed for the individual that's receiving it. And that's, and again, we'll probably talk about this in another program. We talk about child support. You talk about what they call just unallocated support, which is both child support and maintenance wrapped up and together. It's not allocated in terms of what percentage, and that can be a good bargaining chip in order for somebody to say, hey, listen, we'll give you this much, because the person who's paying it is going to be able to deduct that from their income. But the person who's receiving it is going to have to report that as taxes, and there's going to be liability there.
Well, let's talk about a part of the marital estate which is often overlooked until a client goes to speak with an attorney. And I find this a lot in my practice. That would be the pension, profit sharing, retirement benefit, 401k, whatever you want to call it, that the parties have. What is the deal with that?
Well, you're entitled to if you've been married, let's take just an easy example. You're married to somebody, you start a job, and your job has a pension, so you're building up the pension. And that was acquired during the course of the marriage. Now, 10, 15 years later or so, you've built up so much in that pension. Well, you're getting divorced. Your spouse is going to be entitled to at least half of that. Again, the allocations are different, depend upon many other factors, but at the very least,
right,
fair way to say that is half.
Even though the spouse didn't earn it,
that's right,
the non-working spouse didn't earn it, and even though that money was not brought home into the marital estate per se and put into a joint bank account, it just accumulated in the working party's account. That still is both of their money, is it not?
Right. It's really a contribution to the marital estate. You got to think of it as an estate, and that's the whole idea. Two people being married, they become one. Okay, and that's the same idea. Everything you do is is to benefit the marriage, to benefit that marital estate. And so when you think about it, it's really more of a difficult issue. It's really more of a difficult issue when things get more complicated. When people make more money, then that's going to be the focus of a lot of discord, right?
Sure.
But it's also something that's more complicated too, in terms of tax-wise and in terms of drafting what they call a quadro, qualified domestic relations order, in order to allocate that percentage. So let's say that you've agreed that you're going to split it 50-50. Or even in the case of doing a trial and the judge saying, okay, half of this, your pension is going to go to your spouse. Then you have to draw up a separate order that gets presented to the pension plan administrator for whoever the employer is to approve it first. And a lot of times people have different schools on doing that. Sometimes people will just prepare those documents and just get the order entered, and if it's not consistent with the pension plan and all that, then they can modify it. But the better rule of thumb is to do what initially said, is to, hey, first you get it, you get a lot of pension plan administrators have a quadro packages, are things that they expect to be in the order. And that doesn't mean that all those things have to be in there. That's just some of those things that they expect. So then you receive that package, you look it over, you maybe use some of that in aiding the drafting of the order that you're going to present, and then you tender it back to the pension administrator so that it gets approved preliminarily. And then after that happens, then both parties sign it, and then you present it to the court, and then you're done. You don't have to worry about going back. And that can be an expense because generally divorce attorneys charge on an hourly basis.
Sure.
And that requires time.
In your experience, what's the likelihood of getting a 50-50 split as to all the property as opposed to a disproportionate share, a 60-40? A 75-25. What, in practice experience, what do you see being the usual case?
I see, for the most part, because we get different kinds. We get uncontested. We get somewhat contested, but they're contested on different issues. It could be child support. It could be custody. It could be all those other things. But for the most part, it is a 50-50 split. People come in and they want to be fair to the other spouse. They just want to get the marriage over. They don't want to have to worry about going through all the litigation and everything else. So for the most part, it is 50-50. Now, again, when you come to marital estates that have significantly more money, then what do people want, Dave?
A disproportionate share?
They want the money. They want 90% of it, and they want the other spouse to have 10% of it.
Okay.
That's just the way that works. But for the most part, it gets spread out.
All right. Well, that's a nice segue, because where is most of the money? It's in the real estate, is it not?
It is most often. It's in the house.
How in the world do you divide the house?
Well, there are several ways that you can handle that particular issue with the house. You could sell the house and divide the proceeds. Again, I'm just speaking here now with our continuing example of 50-50% on everything else. And so you could sell it and divide it. You're going to have to pay the realtor fees. If you use a realtor, and generally you're probably going to do that, you're probably going to fight about value. who's really going to use, who's appraiser, which attorney are we going to use to take care of
One party might not want to sell either. That might be the marital home for the last 10 to 20 years, and
that's true.
They want to keep it. Are they able to do a buyout?
They could do that. They could do a refinance, if they're in the position to be able to do that. And essentially, then the difficulty that comes in there is the same things we were talking about. Is okay. Well, how do we evaluate? You're going to get an appraisal that's going to be, $10,000 or $20,000 less than the appraisal that I'm going to get, because it's better for you, because it's less that you have to pay to me. But my appraisal is going to be more because, hey, I want more from you. That's just what the numbers kind of work out, a lot of the time. But that's what people often do.
Well, I think every phase of the case has to be a compromise. So in situation that you just mentioned there, why not get 3 independent appraisals and take the average? Wouldn't that be wise? That
would be wise. But again, understand that divorce is a very highly emotional event. And people... unfortunately, a lot of times, even when it's kind of friendly, a lot of times what they just want to do is hurt the other person. It's difficult sometimes for them to let go. But that would be the better course of conduct. It would be to get 3, knock out the high and the low, and go someplace in the middle, or average them out and take the mean. Either way. But sometimes, and unless the other party agrees, then you're going to have the judge make the agreement. So parties do have control over the outcome, but it is a compromise. And if you don't compromise, then you're going to let somebody else who doesn't know really necessarily all the intricacies with respect to your marriage make that decision for you.
Now, you practice primarily in DuPage County, is that correct?
I do most of my work in DuPage County, but we also practice in Cook and Will and in Kane. It depends on where the need arises.
Can you talk about the timeline or time frame that a contested divorce case would take in DuPage County from start to finish? On average, of course.
A contested divorce case can easily take up a couple of years. Easily.
Even if there's not children and there's not a custody situation that has to be explored?
That certainly will extend it. But here's just to give you an idea. Once somebody files a divorce case that has to be served, process has to be served on the other individual. They get served, then they have 30 days from the date they were served to file their appearance and their answer to the petition for dissolution of marriage. All that happens, and generally in DuPage County they set a status date. I think it's 90 days out or something like that, which is an automatic status date to keep on top of it. Then what happens is that people do discovery interrogatories, which are written questions to try to find out a little bit of information about where somebody has money, where they have property. But a lot of times...
Don't they already know this typically?
Well, some of them do, but not necessarily, because a lot of relationships, either one or the other spouse is the one that's primarily responsible for the finances. And when you're in a situation like that and you don't have access to any of those records, you're in a real bind. And so sometimes you're going to be required to do that, because it's unlikely in a lot of circumstances that somebody is going to give up that information willingly. And so through discovery, you get an opportunity to make sure.
It just seems like quite a paper chase to gather all your banking information, all of your assets and titles and insurance policies. And then when they take it one step further, and this is the part that I really don't like in a simple case, they schedule depositions. What is the purpose of that?
The purpose of it, now once after you've gotten through the written discovery, okay, the interrogatories, which are those questions that you answer under oath, and also production requests to produce those things that you were talking about, then you get an opportunity to talk directly to that person. That's the deposition. You depose them. And it's generally the two attorneys, the person who's being deposed, and the stenographer who takes down everything, all of the questions and all the answers, and it's done under oath. And that gives you a chance to explore some of the issues that you may have as a result of reading their answers to the questions that you propounded.
Okay, so after the discovery process, you've basically unearthed all of the assets, all of the liabilities. You know everything about the parties. You know it's a open book. Is that correct?
Well, I don't think you ever know everything about the parties. I don't think it's ever really quite an open book. Everybody has a different take and a different story about each individual. But that's kind of going along the same deal. That's the whole purpose. That's why it's called discovery, because you want to find out as much about it as you can. Because again, remember, it's a marital estate. And in order to be able to equitably divide the estate, you have to know what's out there.
I understand that. I just feel that if the parties are reasonable and they do a four-way conference, which is basically the parties and the attorneys,
yes,
and they talk about the issues, they talk about the property, they talk about the debt, I think if people are reasonable, and that's the key, you can have a divorce case wrapped up in hours instead of years.
Oh, you can. That's absolutely true. If you're in agreement, if everything is negotiated beforehand, and again, people are being, as you say, reasonable from beginning to end in DuPage, within a month or two, at the very latest, you could be divorced. And that would mean that you file everything all at the same time.
It just seems like it would be a whole lot easier on the parties, mentally, financially.
It's a whole lot cheaper, too, is what I was going to say, too, because in that situation, you're going to save a ton of money. The longer that you allow litigation to continue and to fight about something, the more that you're going to pay. I had a case a long time ago, and people were fighting about the little... there's little lamps that are solar powered that you stick along your driveway to illuminate your pathway.
Yes.
And the client really wanted them. I mean, this is something that you can buy for $50, $75, say even $100, okay? But he wanted me to fight for those things, which was going to cost him probably $500 or $800 for the $100. And I don't think it really was about the light. It was just about not being reasonable.
Right. It gets even more petty than that. I call that the toaster and the steak knife dilemma. You can easily go out and buy those items again. You just don't want that other party to have it, which is really wrongful.
That's exactly right. That sure is. But unfortunately, a lot of people are like that. Divorce is akin to a death.
Sure.
It really is, because it's the death of a relationship, and the longer it is, sometimes the more hurtful it can be. If it's death of a relationship that's been 25 or 30 years, and I've represented a couple folks who've been married for that long, and it's just you just kind of wonder what went wrong along the way all of this time, and all of a sudden now they're going to want to get a divorce in their golden years. So,
right. Unfortunately, it's a social dilemma, and the courts are often ill-equipped to really resolve it properly. But it's the only remedy or option that we have is to go to the courts for it. So.
That's right, because people certainly aren't going to agree. If they could agree, then perhaps their energy would have been focused on their marriage rather than what they could get out of it individually.
Absolutely.
Yeah. There are so many areas, and I know we're going to cover some other things with respect to some other upcoming shows, but kind of digressing just a little bit, there are other options about the house, and I think that that's something that we'll probably more fully address in a further show coming up. But again, with respect to divorce, it's very much alive, right, and unfortunately very prolific. Right.
There's so many areas to cover, and we'll do that on another show. Thank you very much, Jesse, for being a part of it tonight.
Yeah, thank you.
And thanks for joining us for Legal Action. We'll see you next time.
Thanks.